Right, now let's get more analysis to what's unfolding today at the Centre Meyiwa Murder Trial. Mpumelelo Zikalala joins us now from Durban for some legal commentary about what he's been seeing throughout the trial. Thank you very much, Mpumelelo, for your time here on all angles. First, I want to discuss the fact that this new application, if I could call it that, has now been brought to court when today was supposed to be another discussion about jurisdiction. Just explain to me in terms of legal procedures, was Advocate Defo not supposed to hand in his heads of argument to his colleagues anyway, even though he has this letter that the NDPP is now considering?
Now, we must look at the nature of the application. Now, in this case, he's simply fighting about the rights of his clients in terms of saying, I want my clients to be safe, I want my clients to be well taken care of while they're in prison, but most importantly, it's the safety or the safety of their lives. So this has to do mostly about the Correctional Services Center. Now, the Correctional Services Act will take care of that and prescribes minimum standards in which our prisoners to be subscribed with. But most importantly, there are proper complaint channels, if I may call them that one has to address. Now, you only come to court when those complaint channels have been exhausted. And the way in which you do it is that you must submit to the court well in advance and also to your former colleagues. Nothing should be submitted covertly without your fellow learned colleagues having knowledge of what exactly what you are going to submit. And you must also look at the end result. Is this going to achieve the purpose or the intention, meaning the submission of this court to the address that will be made by Advocate Defo, is it going to guarantee the safety of his client? If the answer to that is no, then he must use other channels so that at the end of the day, he's able to put his point across. Now, what he ought to have done earlier, if he had representation, was to say, we have looked at the docket. You can see that there's nothing that implicates our client in terms of the other elements that are there. Instead of going through the trial from start up until end, let us show you, by you I mean the state, your inefficiencies or the lack of a strong case when it comes to our client, so that at the end of the day, you may reconsider whether you still want to charge them or not. Now, that is allowed. This is not the process which is presided over by the courts. It's a purely discussion between the accused and the state, and it's the prerogative of the state to then come back and say, we're going to withdraw these charges against this particular accused because we can see that at the end of the day, we're not going to get a conviction.
And coming to the fact that they're discussing now correctional services and the Kgosi Mampuru Correctional Services Facility, at some point, Advocate Mshololo was saying that would be a waste of time because it means that there's a possibility that the officials in that particular prison need to be sent to court to also respond to the allegations made against them in that particular letter, etc. Could this be where we go?
It could be. And the point by Advocate Mshololo is saying that you can't take an order in the absence of someone who at the end of the day would need to implement that particular ruling. So you have to give them an opportunity and say, please respond to this allegation. Is there something that you can do in order to allay the fears that may be held by the accused legal representative? If the answer is yes, then provide those preventative measures. However, don't take this particular decision without the interested party being there, which is a fair point, in terms of saying the correctional services or a rep from the correctional services needs to be at court in order to listen to the nature of the complaint and to respond. The letter which is submitted by Advocate Defo cannot be taken as the gospel truth. It needs to be well ventilated, given to the other party, confirmed or denied, and only then the court will come to a certain particular decision. But also linked to that is this. The court is only there to deal with the merits of the case as per the charge sheet. Anything else that is incidental to the safety of the accused, yes, it's in the best interest of the courts, but it's not the core function of the court in order to determine that. But it's in the best interest for the court so that the accused are there to answer as to whatever allegations are laid before them. So procedure is as much as important as the merits in this case, and that's what we seem to be fighting about, or what the parties seem to be fighting about. If the correct procedure could be followed, I think they can all be happy at the end of the day. And the most important thing, protecting the interest of the accused and making sure that they are alive and they are able to come and defend themselves, could be achieved easily.
Mr. Zikalala, let's talk about Advocate Defo's decorum. You know, this has obviously been brought into question a couple of times by those in the legal fraternity. Experts have told us that it actually is untoward. But, you know, looking at the fact that originally today we saw ourselves back in court with this particular case, not for the trial to continue itself, but for the application that he made during the last court appearance to have jurisdiction argued to take the trial to the Johannesburg High Court. Then today we find out from the state and Advocate Mshololo that his heads of argument as the person who applied for this to happen were not actually handed in. And although this falls out the window, then you find out that actually he has now this new evidence that he wants to bring in. You know, where does this put his colleagues? Aren't you supposed to always play open book in court when it comes to some of the evidence that you'll be bringing forward? Wasn't he supposed to at least have the courtesy to let them know, I won't carry on with this particular part because actually I got a response from the NDPP about the letter I handed to them last week?
You're correct. You don't bring surprises on your colleagues. That only happens in movies. In proper courts, you bring adequate notice and you say to your learned colleagues, this is the type of application in which I'm going to make. Please be appraised of it. At the end of the day, I'm going to need you to respond if it pertains to you. But most importantly, the presiding officer, which is the judge in this case, give them an adequate opportunity to prepare themselves so that they can apply themselves to the subject matter which is being dealt with on the day. Now, which is why then you would be able to write well before time to the court and say, we are going to bring this particular application, none is going to come in, we are going to come with another application today. Here are the founding papers of those applications. We've alerted our learned colleagues. This is the way in which they have responded. All that is left today to deal with are submissions in which we are going to do. So don't spring surprises. And the court is quite correct. You must follow the procedures as they are, but most importantly, come back and update the court as to why the particular application is being abandoned. Don't leave things hanging, because at the end of the day, when things have to be reviewed at a higher court, these are some of the causes of concern that will come in, is to say, whatever happened to that matter which was brought in earlier, it must be put to bed, and there must be a clear explanation and a conclusion to that matter. Now, it speaks exactly to the kind of professionalism which is required within that particular courtroom, not only for you as a legal practitioner, but also for your clients. You want to be able to be seen as being doing a very professional and good job in defending your client's rights. If you act in this particular manner, it shows that, one, either you are unprepared or you do not respect the authorities or the court itself, and you don't even recognize your learned colleagues as to their involvement in this particular matter. You can't do it alone. You need your learned colleagues there. Most importantly, you need the court to be on your side. And the only way in which you are going to be able to persuade them and make sure that they're able to listen to you whenever you've got certain complaints, follow the correct procedure and follow the decorum and practices which are used in our courts, and then everything is going to go according to plan.
I think another thing, Mr. Zigalala, that's interesting for us South Africans who either don't get to see how things unfold in court at all. Of course, as a journalist myself, I have seen some of these things unfold, but this particular case is quite special in how many times we've seen adjournments and breaks because of different reasons. But it also, you know, shows the importance of the court, especially looking at, you know, what Advocate Zigalala, or rather, excuse me, what Advocate Mshololo had said in terms of wanting to look at the purpose of fast-tracking this trial for the benefits of those who are in prison and the families to find closure. But at the same time, the judge saying, I can't just let this go if there's somebody whose life is in danger. So there's always, you know, those things that also clash with each other in terms of law.
And you see what's most important when those type of issues crop up is that give the court adequate opportunity to deal with the cause of or the complaint. Make sure that the complaint is filed within the proper procedure which must be followed when you're filing certain complaints. Make sure that you talk with your learned colleagues, which is why, for example, they will tell you while you're still doing your training, come to court an hour early, so that you're able to discuss this particular point with your learned colleagues. When you stand up and make submissions, it's by consent. And it's rarely in instances where there's really disagreements where the court will be forced in to come and make a ruling. So it's all up to the legal practitioners to work together at the end of the day to protect the interests of their clients, the state to protect the interests of the state, which in this case, incidentally, is that of the family, so that this matter is done or it proceeds expeditiously. Now, let's look at the proceedings of today. We have not even heard a single evidence which came from the witnesses. There's not even a single submission which came from the legal representatives that deals with the merits of the matter. It is purely housekeeping matters. A whole day probably would have gone to waste purely on housekeeping matters that could have been dealt with either of the parties sitting down and saying, this is how we are going to move with things. If there are any changes, update us early so that at the end of the day we come well prepared. And anyone who makes a particular allegation must be able to provide proof and make sure that their complaints are tabled within the courts in a proper manner so that they can be adjudicated on.
And a lot of people would call that or would term that tedious, but, you know, it shows how in South Africa everyone has rights and you cannot trump another person's rights. In this particular case, it's a right to a speedy trial, the right for the family to find closure, but also the right for the accused to safety. Thank you very much for speaking to us. That was Mpumelelo Zigalala. He's the founder and attorney at Zigalala Attorneys.